and like people haven't been getting to go to theaters as much. Like we had COVID, we have streamers, and like I love a good stream, but like the movie experience is so special, and it's something that I looked forward to so much as a kid. It's something I look forward to as an adult, and it's rare that something like pulls you into theaters like that. And now if you are going to theaters, it's for a great example. Watching Deadpool and Wolverine in an audience of people.
Oh my
if you're
God.
watching that at home, it's just there's the human experience of people watching and feeling together.
Hey, besties. We are starting to get some new information now about that secret declaration, the identity and the contents of what was included in this declaration that Blake Lively filed more than a week ago when she demanded the court, rather, give her treble damages, punitive damages for filing a lawsuit against her that she claimed was in retaliation to her making claims against Justin Baldoni and Wayfarer Studios. She claims these retaliatory lawsuits were filed under a law in California, 47.1, that awards treble damages in the event that someone brings forth claims of SA and they are credible and brought without malice. And she is asking the court to award her damages, even though the judge in this case did not use 47.1 to dismiss the lawsuit against Justin Baldoni. Amid all of that, she has filed a declaration. The declaration was from an unknown individual who was being kept confidential because they are a possible witness. And due to the fact that they are a possible witness, they want to remain private or secret until and if there is a trial. Now, this is not uncommon and sometimes standard that you would keep the identity of witnesses in a case confidential. And Wayfair responded and said they don't mind that this person remain confidential. In fact, they said, please keep them confidential. But they revealed some information here that suggests that the contents of what this declaration was discussing, alleging verbal abuse by Baldoni, a conversation with Steve Sarowitz, and in this conversation, what occurred. The declaration was very much blacked out. It didn't provide a ton of context. And the main headline we got out of it was that Justin Baldoni accused of verbal abuse. Well, Wayfair came back with their response, opposing her motion to keep everything sealed. They agree that, yes, let's maintain the confidentiality of the witness. But due to the fact that this audio recording that she's referencing includes the voice of Mr. Steve Sarowitz, who is a defendant in this case, and this recording may have been obtained without his consent, we seek full transparency and we want this in the public domain. So their response is the materials concern an alleged recording made by the witness of a conversation with defendant Steve Sarowitz without his consent. Plaintiff seeks to seal the audio recording in its entirety. Although she purported to selectively quote from it in a portion of her brief in the public unsealed version she filed with the court. Lively boldly claims she placed the substance of the relevant information from Exhibit 1 in the public record, flatly ignoring that the person recorded without his consent, Mr. Sarowitz, should be allowed to have the entire recording made public to ensure accuracy and provide context. So this is an interesting change of events. And this is, again, a moment in time where there is question about the kind of evidence that Lively is introducing into this case. Now, whether or not this was recorded without his consent and whether or not it's legal or illegal depends on the state where the recording was made. If the conversation, say, took place in New York, it's a single party consent recording, meaning that only one party in the conversation needs to consent to the conversation being recorded, and they don't have to tell the person being recorded that they're being recorded. If this were to happen in the state of California, for instance, that's a two-party consent state, meaning both parties must consent to the conversation being recorded. Here, they don't reference that it's a single consent versus two-party, only that he did not consent. They cite a previous ruling by this court that the Supreme Court and Second Circuit have long held that there is a presumption of immediate public access to judicial documents under both the common law and the First Amendment. They cite a case called Loam versus International Business Machines 2022. Materials filed in connection with dispositive motions, such as motions to dismiss, are judicial documents entitled to this presumption. Granting motions to unseal a motion to dismiss, finding it is a judicial document for which a presumption of access applies. Where the presumption of public access is at its strongest, as it is here with respect to the materials, the presumption can be overcome by countervailing considerations in extraordinary circumstances. They also cite a case, United States versus Amadeo. Although the third-party witnesses may be redacted to protect their identity prior to the trial, the redactions plaintiffs request are not narrowly tailored to serve the interest of protecting the personal information of the non-party. So there's 3 separate cases that they use as a reason for why they believe they should be able to have at least the contents of the audio be unsealed. So they're not asking the court to expose who this witness is, nor are they asking the court to say what the project was, but rather they're saying, in this court, you have previously ruled that there is a strong presumption that the public has a right to see it. Why? Because those materials will influence the judge's decision and they're part of the judicial process, not background noise. When sealing is allowed, they have to overcome the presumption that a party must show extraordinary circumstances, and ordinary concerns like embarrassment, bad press, or reputational harm don't cut that. And they expect something extreme like safety risks, trade secrets, or genuine privacy violations. And they're basically saying that if you're going to seal it, it needs to be narrowly tailored. It's a lot like when you're seeing some of these documents come onto the docket, which are evidence that they've obtained through discovery. The judge is consistently not allowed the full contents of these documents to be sealed, but rather he's allowing like personal identifying information to be sealed or privileged information to be sealed. So no email addresses or phone numbers or usernames. And then also on the flip side, if it's a conversation between attorneys seeking legal advice, that would be under like attorney-client privilege. She wants the whole declaration and audio recording sealed, and they're arguing that it's overbroad because most of the information, the timing, the context, what was said, and why the meeting happened does not reveal their identity, the witness's identity. And the sealing request fails the narrow tailoring rule. And I think another argument to be made here is that this conversation actually includes Steve Sarowitz, who is a defendant. And so if it's his words, he does have a right to tell the court, I want this to be public. So he says, with respect to the plaintiff, to the brief, plaintiff seeks to seal 2 portions on page 5. 1, the name of the declarant at the top of the page, and 2, a description of how Exhibit 1 was produced in a footnote. The Wayfair parties have no objection to the first requested redaction, but as no explanation was provided for sealing the last sentence in footnote 9 and none exists, that sentence must be unsealed. Plaintiff already disclosed that she produced Exhibit 1. Further, she publicly disclosed the document was an audio tape by citing time markers, minutes and seconds, typically used when referencing audio recordings. Regarding the declaration, she seeks to seal information regarding the timing of the meeting and the context of the conversation recorded without Steve Sarowitz's consent. Other than the witness's name and the name of the project the declarant worked on, none of the information reveals identity. Plaintiff improperly seeks to hide any context for the alleged verbal abuse, why the meeting with Mr. Sarowitz took place and when it took place, and what allegedly happened after the conversation. So with her brief on page 5, she wants to continue sealing a footnote, and then she also is asking them to continue sealing specific witness names. And so they're saying they don't object to redacting the name of the witness, but but they argue that there's no valid reason to seal footnote 9 because she's already admitted she produced it. She's revealed it was an audio recording by citing the time markers, minutes and seconds, which only audio applies to audio. And they're basically saying she's already put this out into the public, so it doesn't make any sense to keep this private. Thus, in a way, kind of trying to undermine her credibility. What Lively wants to continue to seal are portions of the declaration that describe the timing of the meeting and the context of the conversation that was recorded. And Wayfair's response was that the only thing that should be sealed are the witness name and the project name. Everything else, timing, context, and what happened before and after, doesn't expose the witness's identity and should be public. And they believe that she's trying to hide the story, not protect the witness. Their legal framing is that she's not narrowly tailoring this. She might be abusing the sealing rules to cover up context, which could weaken her verbal abuse narrative. And because they're saying that Sarowitz never consented to being recorded, it's asking for full context to be unsealed. And they're flipping the privacy argument that this isn't about protecting a victim, it's about Lively trying to weaponize secrecy. So I don't know. At the very end, they say plaintiff does not provide any explanation why Exhibit 1 to the declaration must be sealed, other than it would invite additional media coverage, which she is concerned will be adverse to her. However, it is well settled that generalized concern of adverse publicity and reputational injury are insufficient to adjust and justify sealing records. Importantly, Lively herself is responsible for the substantial media coverage resulting from her decision to include alleged quotations from Exhibit 1 audio recording Mr. Sarowitz. Certainly, any privacy interest belongs to Mr. Sarowitz, the person who was recorded without his consent. He should be permitted to have the public hear the entire audio recording, not be confined solely to her flawed and out of context purported transcription of the audio recording. Blake Lively's justification when she asked the court to continue sealing had to do with adverse publicity. And she framed it as though the adverse publicity would be for the possible witness, and that the contents of this information, if revealed, could negatively impact that person. Which is, now that we know that the person that's speaking is Steve Sarowitz, it's difficult to rationalize how Lively would then have the right to claim privacy for Steve Sarowitz's words, especially if Steve wants those words out there. They cite two separate cases, Bronx Conservatory of Music versus Quokka, which is from 2021, and its courts have long held that the fear of bad publicity isn't a reason to seal evidence. And then Julian versus Metro Life Insurance, in that courts reject reputational harm as a basis to overcome the presumption of public access. And judges in the Southern District of New York repeat this over and over, that embarrassment, negative headlines, or bad press is not an extraordinary circumstance. So if that's the entirety of her argument in this case, what Wayfair is telling the court is, listen, your own court has already said that these are reasons and justifications that you don't allow for evidence to remain sealed. And what's smart for them is that they're pivoting against Lively, who says we need to protect the witness, to pivoting to it, well, the only person whose privacy here at interest is Steve, because he was the one that was secretly recorded. And Steve, he wants all of it released. He doesn't want it sealed, and she can't claim privacy on the behalf of Steve. So what Wayfair is doing is they're removing anything that would identify the witness, the project, the name, anything specific. And they're saying everything else that is contained in this exhibit doesn't expose that person, but it does expose Steve. And they want the court to make it public so that fair information is out. It's not cherry picked. It's not a one-sided narrative. It shows the full context. And we've already seen that sometimes Blake Lively has taken statements out of context. I know personally, having dealt with her lawyers, She accused me of being part of a smear campaign and being paid by Justin Baldoni with no evidence. Having experienced accusations directly from her team claiming that I am being paid to destroy her by them, it's very easy for me to believe that she would again take something out of context, apply an allegation, or accuse someone of doing something with no proof. They don't want secrecy. Wayfair doesn't. They're saying Lively is the one that's caused this coverage. She wants to seal the full tape to avoid accountability, and they shouldn't let her control the court, the narrative with an out of context transcript while hiding the full recording. We all know that we live in a society that is based on rage bait and using out of context statements to frame narratives in a way that we believe defends our own opinion. This is on this is in the mainstream media, this is in politics, this is in celebrity, this is in cancel culture, and full context does matter. It does. And in here, it sounds like there's information about this purported verbal abuse that may be contrary to what Blake Lively is saying. And the project and the details of what was said in this conversation might be contrary to the headlines that she's gotten from this declaration, because she admits that by filing it, she got headlines. They believe that she's afraid of releasing the full audio because it will contradict the spin she's put on it. And it's for Wayfair, it's like she's manipulating evidence in the media while trying to keep the truth sealed. Wayfair is doing their best to point back to how the New York court there has previously ruled on these types of requests. They're pointing to the Second Circuit and what they've held regarding these requests. And so they're making a presentation to the judge like, this is what your circuit and what this court has already held. Now, we already know that there's heavy suspicion that Judge Lyman has bias. And a lot of people that are following the case feel like Judge Lyman is in the pocket of Blake and Ryan Reynolds. And because some of these rulings he's made appear very unfavorable, many people believe or suspect he's corrupt. The judge has denied he's corrupt. And so there's a heavy suspicion that anytime they seek something from the court, they will be denied. And in this case, there's fair reason to believe or suspect this might get denied. On the flip side, though, recently he reversed one of his own decisions. And so he had recently stated that Katie Case and Brianna Koslow would have to turn over all of these documents that he claimed were not under privilege. Well, Mr. Katie Case's attorney, Max Breedwell, and then the attorneys for Wayfair argued that, well, Jed Wallace was a part of these conversations. Jed was actually a client of Friedman's firm, and he was included with conversations with Friedman and Katie Case and Brianna Koslow. And so he reversed the decision, and he's allowing Jed Wallace, along with Wayfair, to introduce their privilege logs and state what needs to be redacted from these communications before they are delivered to Blake Lively. Blake Lively's team said that this was ridiculous and they had all kinds of time in order to make these arguments to the court, and they're late, which didn't move the judge. He allowed them to file new privilege logs. Therefore, in this case, they very well could say, you know what, we are going to keep this identity private, but we are going to put out the full contents here. And Steve is the party involved and he wants it out there. We'll see how the judge responds, but to me, it's just another sign of the steps and the lengths that Blake takes in order to introduce evidence and the possible manipulation she's doing on the docket for her to get the headlines that she wants. If something is exposed in there that the verbal abuse isn't verbal abuse, that might hurt her narrative. The timing might also hurt her narrative. Say the conversation happened suspiciously after Blake came forth with claims, and it looks as though Blake is influencing the person to do this. And then the other question is, why is the person recording this, right? Why did they record it and then give it to Blake? There's a lot of questions there, and there's a lot of suspicion on the Wayfair parties. And is this something that was motivated or manipulated by Blake to do for her on her behalf for her case? She's already shown that she's willing to take very unusual steps to obtain evidence. And I don't see them asking to file charges against this person. They're not citing any laws that were broken, but they are saying, if you're going to at least record me without my consent, we're going to put it out there. And judge, you need to do that too. So, what are your thoughts about Van Zandt Point 2? Oh, Van Zandt Sham 2.0? Is that what this is? Tell me in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed. And please click the bell so you never miss a video. Thanks so much for watching. Bye, besties.